And the challenge is that if you go before the Supreme Court now, even though we have the full complement of the court, if you appear in the Supreme Court in connection with any matter, you're likely to get a date in the next 4 years.
Well, I thank you, Professor, my chairman, for allowing me to ask one more question. Just for enlightenment, there is a raging argument now about Supreme Court being overloaded with a lot of cases. And some are even recommending that we increase the number of Supreme Court justices, which I am one of the persons saying that. But they have the argument that even if you increase the number, I'm proposing 30. The argument is even if you increase the number to 100, and the cases, all the cases still end up in Supreme Court, that we might end up not solving the problem we are trying to cure. So what caliber of cases do you think should not get to Supreme Court?
The distinguished senator that just walked in, if my recollection is correct, we were together at the Nigerian Law School.
Yes. I wanted to ask you where you are from.
Thank you very much, sir. And I'm very delighted to appear before you and your colleagues. I'm very grateful for the opportunity that I had to work with distinguished senator when he was the National Organizing Secretary of our party, the APC. I'm delighted to appear before you this afternoon, sir. You have raised very significant issues. In the face of these contending perspectives, I actually take the view that the solution is not to increase the number of justices. I take the view that what we need to do is to reduce the kinds of cases that came to the Supreme Court. And I also take the view that the Supreme Court should actually sit en blanc. In other words, you should have something similar to what obtains in the United States, when in respect of every case, the 9 justices of the US Supreme Court sit. And the reason is because the Supreme Court is the court of last resort. It is also a policy court. And yet we sometimes find that when justices of the Supreme Court sit in panels, you have conflicting decisions from different panels of the Supreme Court in respect of the same subject matter. The Supreme Court should be able to speak with finality as a court of last resort and as a court of policy. The other point is you sought to know what kind of cases, in my view, should not get to the Supreme Court. First, there is a proposal, and on the basis of my experience when I served as the lead consultant to the House of Representatives Committee on Constitutional Review, there are proposals, for instance, that cases like landlord and tenant have no business in the Supreme Court. Matrimonial causes. There are those who also take the view that chieftaincy matters shouldn't necessarily have to go all the way to the Supreme Court. Now, it comes with its challenges, no doubt, because when these cases end at the Court of Appeal, the challenge is that you may have different divisions of the Court of Appeal giving conflicting decisions. Now, what should happen in that kind of situation? In the United States example, for instance, the Supreme Court determines its own docket. And so the Supreme Court will allow cases to come before it when they deal with fundamental socio-economic issues. For instance, the death penalty, the subject of abortion, the subject of human rights generally. And where you find that there are decisions that are conflicting from different circuits of the United States Court of Appeal, then the Supreme Court of the United States steps in to provide clarity and finality. So my respectful view is that we need to reduce the kinds of cases that get to the Supreme Court. We need to have the Supreme Court sit en blanc so that all the justices sit. And you raised an equally important question regarding the challenge that relates to applicants for the rank of SIL. Sometimes some of the cases that go before the Supreme Court have no business at all being there. And part of the challenge is because when you look at the requirements for applicants for the rank of Senior Advocate of Nigeria, you need a minimum of 3 Supreme Court cases, as Mr. Chairman will attest to. And these must be within a period of 10 years. And the challenge is that if you go before the Supreme Court now, even though we have the full complement of the court. If you appear in the Supreme Court in connection with any matter, you're likely to get a date in the next 4 years. And so the tendency is for lawyers to then scramble to get pre-election cases and election cases knowing that they are time bound. And so these are issues that I believe need to be engaged. And I hope that in the context of the ongoing constitutional amendment exercise, some of these issues will be thoroughly engaged in a manner that addresses the challenges of the justice sector in a very profound way. Thank you very much, sir.
Just one